Hey everyone, welcome back to my channel Beyond the Briefcase. So today we'll be discussing a very important judgment which is very relevant with regards to Factories Act. You must have studied this particular act. Also, yesterday only Supreme Court gave a very important judgment pertaining to this particular act. So washing and drying, cleaning of clothes, it does come under the ambit of manufacturing process under Factories Act. So this is something which you need clarity with regard to this particular thing because it could be asked in your competitive exam or even in your college. So the brief summary of this particular case is Supreme Court on 3rd of March ruled that certain activities such as washing, cleaning, dry cleaning fall under the definition of manufacturing process. So you must be knowing that like in most of the acts, section 2, it talks about the definition clauses. Most of the acts, in some of the acts, it does come under section 3 and section 4 as well. So it this particular thing comes under the manufacturing process, Factories Act 1948. Also, the court added that the laundry business constitutes a factory under Section 2M of Factories Act 1948. So basically, the Honorable Supreme Court has given a clarity that how we can, you know, bring this particular thing under the ambit of factory and how we can bring this particular thing under the ambit of manufacturing process. So, Honorable Court has given the clarity with regard to both the things. Also, they have said that if they employ 10 or more workers, laundry work is carried out with the aid of power operated machines used for cleaning and washing clothes. So, the bench, comprising of Honorable Justice B.R. Gavai and K.V. Vishwanathan, was hearing the appeal filed by the state of Goa against the High Court's decision to quash the JMFC orders issued process and against the respondent of violations of Factories Act 1948, and therefore the Honorable Court gave the clarification with regard to the same. So the state argued that Section 2K of the Act, the laundry business, qualifies as a manufacturing process since washing and cleaning clothes involve trading articles for use or delivery. So that was the whole argument produced by the state of Goa. And additionally, the respondent employed that more than 9 workers used power operated machinery for washing the premises met the definition of factory under Section 2M of the Act. So the respondent, they clearly said that all the workers were using the machineries and that they were working at the premises, and that does come under the definition of factory. Then they opposed each other's argument, and the court rejected the respondent's argument since the activity of washing and cleaning of clothes didn't create a new tangible product. The business does not fall under the manufacturing process. Instead, relying on the definition of manufacturing process, the court said that once the cloth deposited with the launderer is, after washing and cleaning, delivered for the customer for use, the ingredient of 2K stands fulfilled. So that was the particular thing which the court held. So the case name is the State of Goa and Another's versus Namita Tripathi. Citation 225 Live Law SC 276. So this is the PDF of the case law which uh, uh, relevant to the Factories Act 1948, which I was talking about. And you can see the it was a criminal appeal 2025 specially petition. Do let me know in the comment section that which article talks about specially petition in the Constitution of India, and this is the judgment copy. You can see here all the relevant provisions which was used in this particular case and the facts as I mentioned. And total there are 45 paragraphs, even the precedents which was relied by the honorable court. So this is the judgment copy. So coming to the next, I hope that you have got some sort of understanding that what exactly things should come under the ambit of Factories Act. Moving on to the next important case, which is related to the breastfeeding in public and workplaces shouldn't be stigmatized. So you guys, being an advocate, being a law student, that it's your duty that if you're seeing any female doing breastfeeding in public space, then you need to make sure that they should, get adequate facilities, because now the Honorable Supreme Court, they even issued direction regarding nursing and child care rooms. So we'll look into it. So while asking the states and UTs to act upon an advisory issued by the Union government Regarding the creation of feeding and child care rooms in public buildings, Supreme Court observed that practice of breastfeeding in public places and workplaces should not be stigmatized. So this was a say of the Honorable Supreme Court. Honorable Bench pronounced a judgment in the petition seeking directions to construct feeding childcare rooms at public spaces and buildings. The above observations regarding stigmatization were made in the context of a joint statement by the UN Special Reporter, which recognizes that the over stigmatization regarding breastfeeding in public spaces and workplaces exposes women to unnecessary stress, pressure, or intimidation as well. So this was the whole summary of the particular thing. The court even emphasized that breastfeeding is an integral component of a child's right to life, survival, development to the highest attainable standard of health. It is an integral part of women's reproductive process and is essential for health, well-being of mother and child. And lastly, they even said that such right and obligation from Article 21 of the Constitution of India, foundational principle of the best interest of the child, as enshrined in international law, as well as the Juvenile Justice, Care and Protection of Children Act 2015. Basically, the court emphasized and they even gave a direction to the duties and state to create certain special rooms for the women for the breastfeeding purpose. And they even the court honorable court even held that Article 21 JJ Act, Article 14, 15, Clause 3 of Constitution, they do come uh, into the whole process when we talk about this particular thing. So the case name, as you can see, uh, Sparsh initiative by Avdan Foundation versus of India. So it's a foundation who filed this, petition in the Honorable Supreme Court. It was a PIL. You must be knowing that Article 32 deals with the PIL of Supreme Court. So this is the order sheet. It's not a judgment. It's just order. You'll have to understand that there's a difference between order and judgment as well. It's a long order and which was directed to the center and state to make sure that all the women females they do get this proper facilities in every part of India. So that's it from my side. Do let me know in the comment section if you have any doubt with regard to this particular concept, and I'll be happy to help to answer your query. Thank you so much for watching my video.